everyone, and thank you for joining us for this Ask Me Anything program, The State of Immigration in America, Asylum and Crisis. You can watch our previous Ask Me Anythings on HIAS Pennsylvania's YouTube page, on our website, www.hiaspa.org, and in the video section of HIAS Pennsylvania's Facebook page. My name is Cathryn Miller-Wilson, and I'm the Executive Director of HIAS Pennsylvania, a nonprofit whose mission is to provide immigration legal services to low-income immigrants and refugees in Pennsylvania. We have all been witnessing, to our growing horror, the demonization of immigrants, immigrant families, and frankly, all Americans who are not deemed, quote, American enough as defined by our federal government. While the attacks are horrific for the individuals and families who've been kidnapped by federal officials and torn apart, we also know that witnessing them has been both confusing and troubling for the general public. Prior to the current moment, immigration law and policy was confusing and counterintuitive. The current moment builds on that confusion and reveals a situation of almost non-stop lawlessness. But as frustrated, angry, and depressed as we all feel, it still remains true that knowledge is power. So tonight, we're doing our best to share our knowledge of what's going on, to unpack the details of what is happening with our very own asylum expert, Chris Setz-Kelly, who's our program manager for our Asylum and Removal Defense Program, with the hope of providing all of you with the knowledge to be able to fight back. So let's dive right in with my questions. And if any of you have questions, please write them in the Q&A feature. There's an icon at the bottom right of your screen, and we'll do our best to get to them as they come in. So I'm going to start with the basics, again, recognizing that asylum law is pretty complicated. So Chris, tell us, who are asylum seekers and how are they different from immigrants and refugees?
Thanks, Kathy, and thanks to everybody for attending tonight. So asylum seekers are individuals who are fleeing persecution from their country of origin and who are here now seeking protection under international law because they have a well-founded fear of persecution in their home country on account of their race, religion, membership in a particular social group, political opinion, or national origin. Asylum law has basically been around now for several decades. It's something that really grew out of a lot of the international consensus following World War II and the series of international agreements that sort of grew out of a desire to prevent future atrocities akin to the Holocaust going forward, which is why you see that the asylum standard here in the United States is present in a lot of different countries' sort of asylum frameworks and refugee protection sort of legal frameworks.
And so briefly, is the legal standard for getting asylum status or refugee status the same?
It is actually. So to qualify for asylum under the Immigration and Nationality Act, you actually have to demonstrate that you meet the definition of a refugee. So the two statuses require that the individual demonstrate the same fear of persecution. The difference between asylees and refugees is really the way in which they obtain that status. Refugees are vetted overseas, oftentimes in a refugee camp administered by an international organization like the United Nations, and then they're resettled in a number of countries, including the United States. Whereas asylees are individuals who are already present in the United States and who apply for asylum status through various government agencies, sort of depending on the posture of their case.
Got it. So are asylum applicants guaranteed the right to an attorney?
So what the government says is that asylum applicants are provided, or I'm sorry, have a right to counsel, but at no expense to the government, which really means that a large number of individuals go without getting representation in their asylum case. And for those individuals who are unable to afford a private attorney, it's often only organizations like HIAS PA and a few others in the area that potentially have the ability to assist that individual and represent them for what we call in the legal profession pro bono, meaning for no fee or providing free legal services.
Okay. So tell us, what role does a judge play in asylum determinations?
So immigration judges are actually employees of the Department of Justice. They're a little different from what we might think of as federal judges who have to go through the Senate confirmation process after being nominated by the president. Immigration judges instead are just hired sort of out of the civil service ranks. And what immigration judges do is they preside over removal proceedings, which used to be called deportation proceedings, sort of under prior iteration of the law, but now the term is removal proceedings. And so many of our clients who are seeking asylum enter the United States without like a visa or valid document that would otherwise permit them to remain in the United States and are immediately put into removal proceedings. And so they're actually applying for asylum as a defense to deportation. And it's the immigration judge whose job it is to listen to the testimony of the applicant and consider the evidence and the arguments from their attorney and ultimately make a decision on their case.
Okay. So can asylum applicants work while their cases are pending?
They can work. So asylum applicants do have the right to apply for a work permit. They're not allowed to work immediately upon arriving in the United States. They have to have had their case pending for 6 months or longer in order to qualify for a work permit. So oftentimes we see individuals waiting not only that 6-month period, but oftentimes significantly longer than that, just because there are delays in the processing of those applications, which is really difficult, right? Because so often people are fleeing like horrible circumstances immediately, and they're not coming here with a lot of resources. So it's a very difficult position that we put asylum seekers in. My understanding is that it's different from other countries that beyond letting people work immediately when they enter the US, actually provide like social services and financial support and potentially housing in some countries. So it's very difficult to apply for asylum in the US.
Got it. So, how long can it take? I mean, you talked about delays in getting work authorization, so you can't even file until they've been here for 6 months, right? Or until it's been 6 months after they file their asylum petition. So how long might it take after that to get?
So it can take a couple of months. The government is supposed to adjudicate those applications for work permits in 30 days, but they can take much longer than that, especially under like current circumstances where for years, USCIS, which is the agency that adjudicates work permit applications, as well as like a lot of other types of immigration applications, has been like very underfunded. And so they don't have enough people to kind of consider these applications. And there's just more and more sort of like red tape over the years that's sort of built into the system. So we see a lot of delays, which can be very hard.
Got it. So what happens when an asylum application is denied?
So as I mentioned before, many of our clients are actually in removal proceedings when they're applying for asylum. So in addition to having their application denied, the immigration judge is also issuing a removal order, which is akin to a deportation order, meaning that sort of once that occurs, if there's no further sort of action on the case, then the government actually has the ability to deport that person back to their country of origin. Now, there is an appeals process that individuals can pursue by right if their application is denied and their order removed. So they submit an appeal to an agency called the Board of Immigration Appeals, which is also an agency in the Department of Justice. And those appeals sort of work their way through the system. And it's difficult, though, to prevail on appeal because it's very deferential to the original decision made by the judge. So oftentimes, if there's not sort of a clear error or some like egregious like misapplication of the law, the decision stands.
Yeah, no, that's great. I mean, it's not great, but it's helpful as an answer. So we're getting lots of questions from our audience. So I want to go through. The first one is a question about asking for an update about what's being done for Afghan immigrants who are receiving temporary protective services or who were vetted elsewhere in order to receive protected status in the US. And before I give it to you, Chris, I just want to kind of unpack a little confusion surrounding the Afghan crisis. Um, so, most Afghans who arrived in the country as a result of the emergency that happened in August of 2021, they were given something called Afghan protected status, and then were, by congressional act of September of 2021, treated like refugees. So what that meant is they were allowed to have work authorization and also to have services to help them enter the country, which an asylum seeker is not entitled to those services until and unless they get asylum. So that was a big difference. They were provided with services immediately upon landing, but the congressional act also required them to then follow up with an application for asylum, which, according to the congressional act, they promised to have adjudicated within, I think it was 90 or 180 days. And they, of course, broke that promise and didn't process the asylum applications quickly. So then they had to create this temporary protected status, to deal with the fact that people had asylum applications that weren't adjudicated, that were pending. And they wanted to make sure that they weren't deportable. They also created the temporary protected status because after the initial crisis, there were Afghans that were still coming into the country because of the Americans pulling out and the Taliban taking over, but it was kind of past the emergency. So they fled from Afghanistan to Qatar, and then from Qatar went through the process to come to the United States. So if they got refugee status in Qatar, then that was great. Then they could proceed as a refugee. But if they didn't, and they needed to apply for asylum, and then time was running out on that, then they needed to apply for TPS. So it's all, of course, as I said in the beginning, very, very confusing. So in terms of the update, Chris, do you know what the status of Afghans that are here? I mean, there are those that have received either refugee status or asylum. They are good to go. But those that didn't, and are simply on temporary protected status, what's going on with them?
So the US government announced earlier this year that they were going to end temporary protected status for Afghans as of May 20th. So many of all of those folks actually who were solely relying on temporary protected status as the basis for remaining in the US are now out of legal status. So anyone in that situation, I think it's really important that they speak with an attorney and sort of evaluate their options. I think for a lot of them, applying for asylum is going to make sense because it's very clear that the US government is like not going to provide any additional immigration benefits to individuals from Afghanistan, sort of as a national group. I think we can all sort of imagine, that being the case with the current administration, and just every announcement has sort of been about like stripping individuals of their legal protections. And so I think it's very unlikely that there's some type of like omnibus solution for individuals who are not here, who don't have status here from Afghanistan. So I think it's really important that people protect their rights and apply for asylum if they think that they're eligible. I know there's also a class of individuals who assisted the US war effort and were contractors of the US government or worked directly for the US government during the war in Afghanistan, and who have been in the middle of the special immigrant visa process. And those cases have taken many years in many cases. So, that's sort of another group of individuals who I think are looking around and wondering sort of like what the next steps are if they haven't received their visa, which when I say visa, I'm really talking about their green card. So the situation for Afghans is difficult right now. Just to sort of lift up another group of people are those who didn't make it out during the evacuation and who had to come to the US through other means. Like we represent several clients who assisted with the US war effort, but were not part of the evacuation and have had to like make their way to the United States in order to seek protection. And those individuals are like in removal proceedings right now, which I think is really shameful because these are folks who like put their lives on the line to serve US interests and then they were being hunted down by the Taliban and had to escape and we're trying to deport them, which is just pretty unconscionable. So
Right. And I also think I want to highlight one more piece of this, which, you know, I say this everywhere I go because it makes me insane. The current government, you know, has been, their talking points are about people who are undocumented. And what they have in fact been doing is rendering hundreds of thousands of people, they're making them undocumented. So in other words, what Chris just described, the Afghans were documented. They had temporary protective status, which is the legal ability to stay here. And the government stripped that from them. So it is a complete lie that they're trying to just simply protect our borders. They have their own agenda. And as Chris said, it's unconscionable. It's unconscionable for all people for different reasons. For the Afghans in particular, it's given that they put their lives on the line for us, and really makes us as a country less safe because it gains a reputation that, you know, the Americans will betray you in a second, which makes it very difficult for us to have allies in other parts of the world. You know, and the stories that we hear, I mean, these are Afghans. It's not only that they were threatened. I mean, many of them were tortured, imprisoned, and escaped, or they had relatives that were murdered because of their help with the US government. So it's a very real and serious threat. Okay, the next question, so we'll go back to just maybe two questions, the typical and then the current situation. The question is, how does a typical case go? How long does the hearing last? And as I said, you may want to answer that two ways. One, there was the way before this current administration, and then the way currently. So,
yeah, so there's really two ways by which asylum cases are adjudicated in the US. We've talked a lot about the immigration court process, that individuals who have recently arrived in the US and don't have legal status or who have like somehow fallen out of status and are now in removal proceedings apply for asylum in front of a judge. And then there's another process by which individuals who come here on like a visa can sometimes apply for asylum through a means that we call affirmative asylum, which means like applying to USCIS and not the immigration court. And through those affirmative cases, what the government does is schedule an interview that's supposed to be a little less confrontational than the immigration court process. So for the asylum interviews, they can last like 3 to 4 hours. Sometimes you'll have to be called back for like a second interview. But I would say on average, like a client is scheduled for an interview and the interview takes place over like half a day and then they receive a decision usually within 2 weeks or so. And that's sort of how that process is supposed to work. For cases in the immigration court, clients are typically scheduled for either a morning or an afternoon session, and the judge endeavors to sort of hear all of the testimony during that like 3 hour period. But oftentimes there's needs to sort of like push the case to a second hearing, particularly when like the client needs the assistance of an interpreter, because that obviously takes longer, as well as if there's like second or third like witnesses, like multiple witnesses, Like sometimes we'll have family members who also like went through the same experience and can kind of corroborate our client's story, or we'll use increasingly like experts, either like a doctor who's sort of examined our client and can kind of write up a report for us, documenting the injuries that they sort of sustained and the sort of indicators on their body that sort of corroborate that they experienced those types of injuries in their country, like such as bruising and such, like that sort of indicators that remain. And then we also sometimes will use like country condition experts, which are like university professors or journalists who've kind of studied the conditions in our clients' country of origin or the conflict that they were a part of, and can kind of like testify in even more detail about the situation in their home country and why they would be at risk of persecution if they return. So sort of like the more complicated case, sometimes you end up with like, cases that draw or sort of go for multiple hearing days. So like you're talking like 3, 4, 5, 6 hours of testimony. So there's no sort of like one size fits all.
Okay. And is that true in the current regime as well? Or has
I
anything
would say
changed?
so. I think like if anything, like we've seen judges like get more pressure to hear more than like say 2 cases in one day, which was like the standard from like as long as I've been practicing. Now they're being asked to hear as many as 4 cases. So like you'll show up for a hearing and at say 1 o'clock in the afternoon, and the judge is still hearing like the prior case, and the judge just sort of like contacts you during a recess in the prior case and informs you that like they're not going to be able to hear the case today because the prior case is sort of going on still. So there's a lot of sort of, it's a lot more like kind of chaotic with how the court functions, because I think of a lot of the political pressure to jam more cases into the calendar.
Right, right. And I think, and correct me if I'm wrong, Chris, I mean, my understanding about the pressure on hearing more cases is because the current government doesn't believe, in a kind of blanket way, that any of these claims are legitimate. And so they shouldn't take that long, because how long does it take to listen to somebody and decide that they're not credible and they're lying? Right? So there's this kind of attitude based on falsehoods and not based on the actual evidence. And as you described, if you want to prove your case, it requires a lot of testimony from experts about country conditions, maybe medical professionals, et cetera. And then also there needs to be interpretation. And so that also requires time. So,
Right.
yeah. Okay. Moving on to another question. So switching gears, someone asked, what is the current status for Ukrainian war? And she uses the term refugees, Ukrainian war refugees, but I do want to just make sure that we're all using the same term, so that the legal term refugee is specific. I believe that our listener is asking it in the more general way, that they're refugees fleeing war. So they haven't necessarily been labeled a legal refugee. And so what is the current status? She knows that they're in different programs. When they were admitted, what is the likelihood that these programs are continuing? What do you suggest for these individuals? So I do want to stop there. We don't want to be giving advice because every situation is different. But I think generally Chris can tell us about, there were essentially 3 options, and correct me if I'm wrong, Chris, for Ukrainians. They could either come to this country and apply for asylum. They could come as a sponsored refugee in the U4U program that Biden created, or they could qualify for temporary protected status. So that's my understanding. Is that? Oh, you're muted.
Oh, sorry. That's a pretty good summary of the 3
Uh-huh.
options. One clarification is just for those who are sponsored by a US based sponsor, they were entering the US with something called parole, which is like a temporary permission to remain in the United States, and does not lead to like permanent legal status in the US. So no pathway to citizenship. and it's typically something that like has to be renewed periodically. So when the U4U program was announced in 2021, I want to say, we saw a lot of individuals take advantage of that and come to the US. And there was at least one renewal of that like 2-year parole authorized during the prior administration. But what we've sort of seen happen recently is the government has announced that they're like evaluating that program and not granting any new like parole renewals. So, that doesn't make us really optimistic about the future of that program. I think there's a lot of political dynamics that kind of make the Ukrainian situation complicated for this particular administration. So it'll be really interesting to see how they handle that. I think anyone who is relying solely on the parole should look at like temporary protected status, because that is there's been no announcement that that's going to end. So we'll have to monitor that. And then sort of as I was advising with the Afghan community, I think anytime you're on one of these temporary protected, one of these temporary options to remain in the US, and you want to continue to remain in the US long term, like I think it's important to advise to sort of consult with an immigration attorney about other options. Like a lot of folks have family members here that might be able to petition for them to get a green card. Asylum is potentially an option for some folks. So there's no sort of clear direction that sort of applies to everybody, but certainly like you want to be informed about your options and your rights. So I think seeking legal advice is important.
Okay. And one more last piece in that from that listener, they were asking about qualifying for housing assistance, allowing for eligible non-citizens, not clear what that means. And of course, all particular benefits have been kind of thrown into chaos, if you will, by HR 1. And we are going to be doing a program in the fall about HR 1. We're waiting for some explanatory regulations and everything. So I don't want to go into that right now, except to say that it's terrible because they're eligible immigrants, which is a very small group of people, have been rendered ineligible. So that just is plunging more families into poverty and creating chaos. So moving on from that, I want to go to the next question, a hypothetical that comes out of my core concerns for Latina women fleeing the US. If their husbands have been targeted by drug cartels and they've been raped by members of those cartels, do they have a right to asylum status in the US? And I think it's a great question about the belonging to a special social group, right, of asylees or of asylum seekers. So I guess if you could speak a little bit to that, about whether women, whether you can belong to that special social group as a woman.
Yeah, so it's a great question. And I'll probably have a frustrating answer for it because the case law, meaning the courts, when they've sort of discussed asylum eligibility, have always stressed that it's an individualized determination. So there's no kind of like clear parameters for exactly who qualifies for asylum. And in particular, cases involving gangs and cartels and fleeing violence from those groups are extremely complicated because the state of the law is oftentimes in flux, is often changing. So like if someone's being targeted because of their family connection to an individual, that can sometimes be the basis of an asylum claim. So just sort of looking at the hypothetical, that could be a possibility here, sort of tying the fear of persecution to the individual's connection to their spouse. So yeah, like that's a complex
it's
area.
arguable, but
Yeah.
challenging, right? Is that a fair
Exactly.
summary?
Yes, thank you.
Right. Okay. And then here's a great one and a great question, terrible answer. Is the law that deportees must be deported to their countries of origin? How is it that the administration is deporting people to other countries. So, and we can thank our Supreme Court for that, right? So,
Yeah, no, it is a very like unfortunate part of our immigration laws that they are like potentially vague on this point, or like it's explicitly permitted, that once a removal order is issued, the government can deport you not just to your country of origin, but potentially to a third country. And I'll say that this has not been something that has like regularly happened in the past. It has really only been something that like prior governments have considered when, say, an individual is from a country that does not accept their own citizens back when they've been ordered deported by another country. But now we just see, like, for the purposes of cruelty only, really, and scaring people, the administration is like deliberately sending people to third countries when I think in a lot of these instances, they could just as easily, in fact, more easily, just send them back to their country of origin. So it is unfortunately permitted under the law, and it's a very cruel result.
right. And just another example of even before this administration, how messed up our immigration law was, that option was on the books. And then how much worse it got under this administration, who's exploiting that option unreasonably, I would say.
Yeah, and I'll just have one more thing that I should have
Mhm.
mentioned in my answer is individuals should have the right, if they're going to be deported to a third country, to claim that they fear return there. So typically when people go through the court process, they're applying for asylum from their country of origin because that's where they expect to be sent back to if they're ordered deported. But now that we're facing the reality that the government is actually trying to send people to third countries, the law supports people having the right to claim asylum or other protection from that third country. So this is like a very like emerging area where a lot of attorneys and organizations are doing a lot of great work to try to force the government to provide people with more notice when they are potentially going to be sent to another country that they weren't previously aware they could ever be sent to, and to allow them to have the option of at least like claiming a fear of returning to that, or not returning, but being sent to that country in the first instance, so that they can potentially have a hearing where they can demonstrate why they would be harmed if they were sent to that third country. So I'm not trying to say that like even if the administration is pursuing this and that there's some support for it in the law, like the way that they're doing it right now is pretty unconscionable, and that there are options for people, but it's an area that like it's an area where we're just seeing like new case law emerge like week by week because it is such a like novel thing that this administration is doing.
Yeah, and I think a good example, would be someone who's LGBTQ who comes maybe from Guatemala, and who ends up having a removal order, and then they try to remove him or her or them to Uganda, where it's the death penalty to be LGBTQ. I mean, so, that's a kind of situation where the law does require that you be given an opportunity to show why it would be your life would be in danger if you got sent to this third country. But yeah, so lawyers are making those challenges. Right. Okay, so and here's the $1 million question because of what's going on. If a person has been granted asylum and also applied for a green card, are they still at risk of getting deported? So I guess the first thing is to know that if you've been granted asylum, then you also, then you, after being here for a year, you're eligible to apply for a green card. So that's the first thing. So let's say you're in that, you've gotten asylum, you're here for a year, you apply for a green card. Now what? Are you still at risk?
So most people who have a green card are permitted to live in the United States for the rest of their lives and after typically like 5 years, can apply for US citizenship. One area of our sort of immigration system that's unfortunate is we do allow the government in certain limited circumstances to seek the deportation of green card holders. The most common instances in which that happens are folks who have serious criminal convictions. But even though I use the term serious, like it would probably surprise a lot of people, like some of the offenses that can actually lead to somebody being deported. So, like marijuana is a great example, like societal views of that have changed. There's states where it's legal, but if you're convicted of certain offenses involving marijuana, like you can lose your green card and be deported over it. So I'm always advising clients once they become eligible to become citizens to go ahead and go through the process, because you don't want to ever be in a situation where you're at risk of deportation. So you're never truly safe
Safe.
in some way, is one way of thinking about it until you're a US citizen.
And I think this is where it gets particularly tricky, and Chris, correct me if I'm wrong, with this particular administration, because again, it's always been true that you could get deported even after you get a green card, even after you become a citizen. If you commit a very serious crime, let's say you commit a treasonous terrorist act, right? The most serious thing we can think of. You could be stripped of your naturalization, you could be deportable, all of that has always been on the books. But it it was nothing that it was rarely applied, and certainly not applied with minor offenses. But under this administration, they have made it their mission to essentially go after everybody. Is that correct? I mean, I just read a story in this morning's paper about a Korean a professor who's been a green card holder for 35 years and is doing research into Lyme disease. And he went to South Korea to for his brother's wedding for 2 weeks, came back, and he's still in detention. It's been more than a week. And they're claiming that, well, he had a marijuana conviction from, I think, 10 years ago. I mean, something that just would not have happened, even though it could have. Is that
Yeah, I mean, unfortunately, our laws have always been really harsh, and the enforcement of them towards permanent residents who have criminal convictions. Um, it's a lot of, we might talk about detention in a little bit, but a lot of people in immigration detention are those long-term green card holders who have criminal convictions. So it's certainly an area that the current administration is prioritizing, but I would say it's been an area of focus for many years now. One like clarification I would make is generally US citizens can't be deported for crimes that they commit in the US. We do see, or you do see sort of stories in the news about denaturalization, but those typically involve individuals who committed some past act that would have made them ineligible to receive like their green card or their citizenship. And the government sort of discovers it like after the fact, after they become a citizen. So there's like a lot of cases involving people who were like complicit in like war crimes before coming to the US. And they come here, sometimes as refugees. There's not a lot of these cases. I might have used the term a lot, but there are these cases, and they're sort of illustrative of like what a denaturalization case can look like, where somebody commits like literally crimes against humanity and then comes to the US and eventually becomes a citizen. And in those circumstances, you'll sometimes hear about a denaturalization proceeding, but it's still like quite rare, because my understanding is that it's very difficult to sort of prove those cases, and it takes a lot of resources on the part of the government to do it. So
right?
just want to sort of make that distinction between like denaturalization and like those who are permanent residents and potentially at risk of deportation because of criminal acts.
No, that's helpful and important. So the next question, can an asylum applicant apply for legal status proactively, or must it only be a defense to deportation? So that's the affirmative or defensive, right?
Yeah, exactly. It's a good question. So there is a way for individuals who are not in removal proceedings to apply for asylum, and it's through submitting an asylum application to USCIS, which is another government agency. And this is the process by which the applicant is scheduled for an interview. And it's a little different than what a court proceeding looks like. It's at an office, like a immigration office instead of like a courtroom. There's not like a government attorney sort of prosecuting the case against the individual in the same way that there is with a removal case. So there is that sort of different process for individuals who are not in removal proceedings.
All right, and then the next question is ICE currently picking up and detaining asylum applicants? So people who've applied for asylum, but they haven't received it yet.
So there have been reports of individuals being detained at asylum interviews. It's still not happening in like the majority of cases. So I'm trying to be very careful to like not say that like a trend is indicative of like what's happening in every case, but there have been reports of that. It seems like the government is really prioritizing individuals who arrive in the US recently, and in some cases prioritizing individuals who utilize some of the parole programs that were announced by the Biden administration, and by which a lot of folks from places like Cuba, Haiti, Nicaragua, and Venezuela came to the US. So that is happening, unfortunately.
Yeah. So switching gears a little bit, the next question is about immigration judges. And there was a story that I think many of us saw about a judge who had excellent performance reviews who was fired with no explanation. And I guess I wondered, well, I know you can't comment on her situation because she was a judge, as I understand it, in the Midwest. But is the administration, to your knowledge, letting go of immigration judges who are generally more favorable to asylum applicants?
I think that's absolutely happening. I don't know exactly how the administration is making the decision on which judges that they're trying to let go of. But that's definitely been reported, and there's been instances of former judges now doing interviews and sort of talking about how like they receive directives from their superiors at it's called the Executive Office of Immigration Review, which is the agency that runs the immigration courts. They've received sort of orders to do something in particular cases, and they've refused because they don't believe that it sort of corresponded with how the case should have been handled under the law, and they've been fired because of it. So we're definitely seeing the politicalization of EIR, which is the immigration court system, as well as the appeals court that hears those cases, the Board of Immigration Appeals. And it's just showing that like these agencies are very prone to political manipulation because they are executive branch agencies. And so the president and sort of everybody down below that can kind of exert pressure on these agencies, which is why there's been at times like a movement to make immigration courts what we call Article 3 courts, which is Article 3 is the part of the Constitution that sort of sets up the federal court system. So the idea is to like make immigration courts independent courts, like most federal courts, where you have judges who aren't being like subjected to political pressure and who can exercise more independence.
Now, here's a question. Does the way you enter the country affect the results of the asylum process?
So under the law, it really shouldn't. You have the right to claim asylum under the Immigration and Nationality Act, whether you enter the US legally or without legal documents. Sometimes individuals are processed different ways depending on how they enter the US. So there's something called expedited removal, where individuals who enter the country without legal authorization through a port of entry, basically show up to the, let's say, the international bridge at the southern border coming from Mexico, and they don't have a visa or anything, they could be issued what's called an expedited removal order. And so they then have to pass like an initial screening for asylum before their case is even put into court. And if they don't pass that screening, then they can just be they can just be deported based on that expedited removal order. So there are different ways that cases are handled depending on how folks enter the country, but there should always be some means through which an individual can like claim asylum.
So that's good to know. I, want to kind of go relatedly, because there was an earlier question that I saw about people being detained at their asylum hearings. And I know that one of the reasons that was happening, or is perhaps still happening, is the definition of how you qualify for expedited removal was expanded under this administration, so that now, right, anyone who's been in the country under 2 years, regardless of like where you are or in the process, could be removed essentially without a hearing. So my understanding, and tell me if I'm wrong, is that what was happening is if there was an asylum hearing, but then ICE discovered that the person who was seeking asylum had been in for less than 2 years, they went to the hearing, withdrew the charges so that there would no longer be a pending application, and then immediately turned around and arrested them so that they could go through expedited removal. Is that accurate?
That is happening,
Mhm.
and it's happening primarily in cases that are sort of at the early stages where individuals are showing up for their first hearing. So just to sort of explain, like typically in the immigration court, an applicant has to show up to court and present their application to the judge. And the judge will give them another date to come back for like the final hearing, which is oftentimes like several hours long, and that's where they'll testify. So we've seen that the government is now trying to dismiss those cases at those early stages, oftentimes before the individuals even file their asylum application, and put them into expedited removal. So there are like sort of limits on who can be put in expedited removal. So it is like a limited class of people, but it's primarily individuals who recently arrived in the US. Before 2016, there was a regulation that was basically confining expedited removal to individuals who had been here for 14 days or less. But the Immigration Act, the act of Congress, actually allows up to 2 years. So we saw, the administration during the first go around throw away those regulations and create new regulations, like allowing them to use expedited removal up to like the full statutory authorization. So that's where we start seeing like 2 years being sort of the benchmark by which individuals can be put in expedited removal. And they're even trying to push it sort of beyond that in certain instances, like individuals who entered on parole. Or this is again like an area that's very much like in flux because there's a lot of litigation over it, but it is happening.
Right, right. All right, so switching back to gender-based violence, you talked briefly about this earlier about the difficulty of women belonging to a special social group. But a listener asked, can you discuss a recent case that states that gender-based violence is not a basis for asylum? Is that on appeal? Is, you know, so.
Yeah, so I think what the question is referring to is there was a Board of Immigration Appeals decision that was published, and BIA, Board of Immigration Appeals decisions that are published are meant to sort of act as guidance to immigration courts in how they decide cases. And in that case, what the BIA said was that a social group consisting or sort of defined as Salvadoran women was not valid for purposes of establishing a particular social group. And there are three sort of like metrics by which an attorney or an applicant has to sort of demonstrate that a social group is valid under the law. I won't go into them, but just know that the BIA said that like Salvadoran women was not a valid social group. So, you know, it's obviously disappointing, but it is sort of in line with a lot of other case law over the last couple of years. It seems like uh, when you have a sort of gender-based violence case, you're having to define the social group a little bit more in a limited fashion than just like the nationality group and the gender. So like there is like a good BIA case sort of establishing that like Guatemalan women who are unable to leave their relationship in like a domestic violence situation, that can be sort of the basis for a social group. So I think this administration is really trying to eliminate a lot of gender-based claims, unfortunately, and we're kind of fearful that even that case I just mentioned could be sort of overruled by the BIA, and then there'll be a lot of like appeals involving that. So, you know, it's definitely not a good time, but those cases are, it's still very possible to win those cases. We won one just a couple weeks ago, so they're still alive and it's still a valid way to seek asylum. It's just they have to be handled carefully and pretty thoroughly.
Okay. All right, so we're getting towards the end of the line, but before we wrap up, I guess I want to focus on two things. One is if you can clarify for us, what is, given all this terribleness, what is HIAS PA doing? I mean, how are we advising our clients? Are we able to advise clients? You know, what's happening within HIAS PA?
Yeah, so our services have sort of multiple dimensions. Um, Kind of the area that I directly oversee is our asylum program, where we take asylum cases on for full representation, meaning that we assist individuals in preparing their asylum application and then go to court with them and prepare them to testify and uh, gather their evidence and submit legal argument on like why they qualify for asylum, and then, you know, even help them appeal their cases if need be. So that's definitely one dimension of our services. And then we also increasingly are doing more clinics where we're trying to reach like a greater swath of the community, because it is very resource intensive to represent an individual in an asylum case all the way through, and we unfortunately just don't have the staffing to do that. So we're increasingly doing more clinics where we're helping people to submit their asylum applications so that they can meet the deadline to apply, which is typically 1 year within them entering the US. And then perhaps helping them get their first work permit, but not necessarily representing them going forward throughout their whole case. And then beyond that, we're also through our intake program, providing a lot of advice to individuals and resources on their rights and how to seek asylum, as well as doing increasingly more and more like community events around like educating individuals on their rights, including how to seek asylum, but also like how the immigration court functions, and hopefully giving people resources that they can utilize while they like look for counsel and um, look to put their application together.
Great. And so for clients, either in the audience or friends of audience members, you can call our intake line at 215-832-0100 during our intake hours, which we'll put in the chat for you all. And you can share that widely, and people can definitely get confidential information and advice. And then in addition, you can go onto our website where we have a whole bunch of multilingual Know Your Rights resources, which you're free to copy, share, download, watch videos in various languages. And then finally, with respect to signing up for a clinic, what we normally do is we notify clients who have called us on our intake who we think would benefit from such a clinic. And that's how we kind of populate those clinics. So again, call our intake during intake hours, which that information is in the chat. So then the final question I want to wrap up with, and I know we're getting very close to time, but you know, we've gotten a lot of questions from the chat about what can we do to help? I mean, do we have resources for the public in trying to help them figure out what to do to keep their friends and neighbors safer? Whether if they're witnessing an ICE agent coming to take someone, is there something they can do? And can we provide information about that?
Yeah, so we do have a lot of great resources on our website in the Know Your Rights section, which I believe is on the front page of our website. And those resources have been translated into several different languages. I think we're like up around a dozen. So there's a lot of great information on how to prepare for if you ever do encounter an immigration agent, as well as how to prepare like in the event that like you do end up in immigration court proceedings. So I would encourage folks who are interested to check those out.
Okay. And yeah, and they tell you basic things like, you know, be polite and stand back, don't interfere, but definitely record. If you have the opportunity, you can ask an ICE agent if they have a judicially signed warrant. So those are things that you're allowed to do. Whether they'll respond to you is a totally other question, but at least you can record with your phone that they didn't respond. And that's helpful for our advocacy and also for organizations like the ACLU, who are bringing a lot of lawsuits across the country about ICE's tactics. So those are all things that you can do. The other thing to just note, if somebody wants to call our intake line, we have language access. And it's fairly extensive. It's way more than 12 languages. So no one should be worried if you're concerned that you can't that the resources that we have aren't in a language that you can access. You can call that number that's in the chat, and we can try to get them translated for you. And for volunteering, that's also on our website. We'll put that in the chat. It's already in the chat, quicker than I could get it out. So that's great. So you can help with your knowledge, you can help with advocacy to your elected officials, keep doing it, keep the pressure up. You can help by steering people to our intake line who need help. You can also help by volunteering, and you can help by donating. So we really appreciate all of you, and you took the first step in helping by joining us today and getting the really critical information about what is a complex area of law. So thank you so much, and I apologize for all the questions that we didn't get to. Take care.